in car wreck cases and in any kind of case that's not workers' compensation, not a no-fault system, fault and liability matter completely. Fault almost never matters in workers' compensation, but in a car wreck case, as an example, fault is going to determine everything as to whether you're going to be able to recover anything. And let me explain to you what the rule is. The common law came from England. It existed before the Pilgrims came to Plymouth Rock. It existed 1,000, 1,500 years ago in England. And the common law then was, because people got hurt, somebody's got loose at the fair, trampled people, somebody swung a hoe, they weren't paying attention and knocked out somebody's eye. These injuries happen. There have always been personal injuries, and people need compensation when they've had that sort of damage. So the rule, though, that was developed under the common law, something called contributory negligence. And the rule is that if the person who caused the injury is negligent, they may be held accountable, but that's not necessarily the whole story. If the person injured also has negligence, they can't recover. So it's commonly referred to if the injured person has any amount of negligence themselves, even 1%. So if the wrongdoer was 99% at fault, but the injured person was 1% at fault, that's a complete bar to recover. That's a little bit of oversimplification, but the answer really is that if the jury finds that the injured person was also negligent themselves, even in a much lesser amount than the wrongdoer, it is a complete and total bar to recovery. In the United States, we have 50 states. 47 states no longer have the law of contributory negligence. They've adopted a more, quite frankly, civilized system, and it's based on comparative negligence. So in that situation, if, for example, a jury finds that the wrongdoer was 90% at fault and the injured person was 10% at fault, and that normally they would have awarded the injured person $10,000, the injured person's recovery is reduced by their amount of fault, which is 10% or $1,000. So they don't get $10,000. They get $9,000 because they were 10% at fault. That's generally how comparative negligence works in most states, but that isn't working with your eye. So when the insurance companies are investigating claims and when they're talking to you on the phone, they are looking for a way to say that they have found some negligence on the injured person's fault, or to get the injured person to somehow admit fault. So a question sometimes asked, is there anything you could have done to avoid this wreck? And a lot of times people are like, man, I wish I hadn't gotten out of bed that day. And then I'd say something like, oh, I guess I should have been paying better attention. Really? Well, you might have just stopped your case. And what you really mean is, I just really regret the whole thing happened. But really, no, there's nothing I could do. I never saw the guy till he hit me. I couldn't see the guy until he hit me. So it's a harsh rule. 47 out of our 50 states have gotten rid of it. Hopefully one day North Carolina will, but it is still the law as of today.